Welcome, everyone. We are pleased to have you join us all today for our four-part webinar series in pursuit of recruits, focusing on the talent, recruitment, and retention in a tight labor market. In discussions with our members and local chambers across the state, we've been fielding questions about what each of us can do, not only to up our game in recruitment as a state, but also personally as employers. So we've assembled a top-notch team of professionals and state representatives to help us answer this question. We'd like to thank our lineup of hosts and partners, including HR Simple, our technology host, Knutson Law Firm, Salary.com, LinkedIn, and HR Nebraska. Today, we are pleased to introduce our first speaker of the series, who will discuss best practices in creating and updating employee handbooks this year and any new provisions to be aware of heading into 2023. I'd now like to introduce you to Chuck Wilbrand, who joined Knutson Law Firm in 2012. He's licensed to practice law in Nebraska and Iowa and specializes in employment law, healthcare law, and workers' compensation law, just to name a few. Chuck has years of experience working in employment law, helping employers with strategic advice to help meet their objectives while reducing potential litigation risks. After the presentation today, we will be offering some time for Q&A, and questions can be submitted in writing throughout the program in the Q&A box. If you are participating today for professional credits, be sure to hang on at the end, and we will give you those reference numbers for the program. And then also a recording of today's session will be sent out to all of you within the next day or so. Thank you again for joining us, and we hope you enjoy our presentation today. Chuck, I'll turn it over to you.
Thanks, Cindy. So I tried to be give us a nice snapshot of things that we wanted to talk about today. It's kind of hard to condense an entire webinar of what needs to be in an employee handbook in just under an hour, but I'm going to touch on a couple of areas of what's going on. I've been practicing employment law since I first started as an attorney, and our firm does, through the Nebraska Chamber, do an employee HR manual kind of guideline of what needs to be in there. Covers a lot of topics on that. So what I'm going to be talking about today, I understand COVID is still an ongoing process, and a lot has changed in even the last year on that, from testing and accommodation. Talking about remote work, we're still seeing how that is shaping every day. Wage and hour and overtime pay, those are two things that could be changing in the coming months. So I'll give a brief overview of that. And then finally, at the end, I'll just kind of go through some legally essential policies that every handbook should have. So COVID-19 testing and accommodations, this has been going on for 2.5 years now. And we've all have dealt with it in our own ways, from office closures to people wanting to work from home to a brief stint of mandatory vaccinations and everything like that. So if anybody recalls, at the end of 2021, there was going to be requirements put in by OSHA saying these areas needed mandatory vaccinations. And there was going to be things with that we weren't sure of what the definition of fully vaccinated meant. Is it 2 shots? Is it the 1 shot of Johnson & Johnson? Is it 3 shots with the boosters? If more boosters come out, what do we get from there? That was the difficulty with it. It was challenged in a lot of courts. There was opinions that said mandatory vaccination policies were acceptable, but ultimately OSHA withdrew the vaccination requirement, and as of right now, nothing has been redone on that. However, COVID's still a thing. Now it's mutating every day, every month to a new version, whatever that may be. So we still have to deal with this. And in my practice, I have always tried to say, let's avoid mandated things. I don't like to mandate vaccinations. I don't like to mandate testing, but we have to be prepared as attorneys to tell our clients, if you're going to do that, this is how you do that. Now, you can have the employers can have policies that say we strongly recommend it. We strongly recommend vaccinations because we're if it's a hospital, we're a hospital and we believe in medicine and everything like that, so we recommend it. But what does that lead us to? The EEOC gave a lot of guidance on this. You need to have there's questions and FAQs being updated almost weekly at the very beginning of what this was going to do. How do you do it if you are going to do it? Accommodations, accommodations, accommodations. That is the biggest way you need to do this. And it needs to be in a reasonable accommodation. So healthcare providers, when you're giving a mandate of such things, like we want you to be vaccinated, and if someone comes in and says, I can't, the accommodation is, can that person work from home and do their job? Or if not, can that person appropriately wear PPE equipment and be protected that way? And sometimes the answer to that is no, that you can't give a reasonable accommodation. It's not always an accommodation to say, let this person be unvaccinated. You could have it say, look, we need you to do so many tests a week or something like that. That's a reasonable accommodation. You had to deal with that. The biggest ones that started coming up, yes, bona fide medical concerns, always. That's something that is any business that you are in. If someone comes in with a medical exemption, you as an employer need to look at that exemption and say, okay, can we make reasonable accommodations with this? The harder one started becoming the religious exemptions. And as employers, you're not the measuring stick of whether or not this is a bona fide religious requirement of their religion. It is not that you get to go and say, well, I know what the tenets of that religion are, and they don't believe that, you can't do that. That's not how it works. It's whether or not that person has a sincerely held religious belief. And so you don't get to go and be, as an employer, you don't get to be the jury on that and the judge on that and say that's not a real thing. But just because they had that religious belief of saying they hate vaccinations or they hate masks or whatever, you have to look at it and say, okay, is this a sincerely held religious belief? And it may be. And then two is just, what is the reasonable accommodation? But employers need to be very careful of entering the pitfall of, I get to judge whether or not this is a true religious belief or not. So that was a difficulty that we started seeing more and more in my practice as this started to come up. Other areas of religious beliefs have always come up, but the resistance to COVID-19, it has been very polarizing, and it's not always easy for the employers to deal with. Now, that then led to, we still have it, people still are popping positive tests as time goes on, and even people that are fully vaccinated and been boosted two times had been throwing positive tests. So what happens when the employee is hesitant to come back to work? Well, again, this goes again with reasonable accommodations. Can you do anything to reduce that employee's concern? And you may not be able to. Some industries cannot do remote work. Some industries can't isolate their employees to have that individual not come back. So when you have to deal with that is have discussions, open conversations of what the person's concerns are, what can you do to accommodate that person? You have to engage in the interactive process. That is going to be the most important part that you take away regarding COVID-19 and testing and vaccinations and everything and exemptions and all of that. Engage in the process. Document the process, that's what you engaged in, and then honestly evaluate whether or not the accommodation for that employee to either come back to work or miss work or whatever is a reasonable accommodation. And reasonable doesn't mean the employer has to bend over backwards to make it happen. Some industries, like I said, cannot do remote work. Healthcare, the nurses need to be able to see patients. Doctors need to be able to see patients. That all cannot happen through telehealth. Same thing with, let's use the food industry. You can't create the hamburger virtually and deliver it virtually, anything like that. You need employees in the restaurant. So it's not always going to be, you can't always accommodate. But what they're requesting needs to be a reasonable accommodation. And you as employers need to look at that and say, can I actually do this? Now, so sure, is it what you prefer? It may not be what you prefer, but if it's not really causing much harm to the employer to do that, or is it not much of an inconvenience for the employer to allow remote work, go ahead and allow it. Don't be so rigid on this. Flexibility helps, but document that you have this interactive process. Document that you talk to this individual. If they email, make sure you save the emails. Those are going to help in case of what could potentially happen down the road. And down the road, they go and file a complaint with the Nebraska Equal Opportunity Commission or the federal level at the EEOC, and then you have to have your documentation when they come and investigate that and say, what did they say? How did you do this? And if you have documentation, that's going to help you down the road. The thing is, now we're to the point is if they have their paid time off, PTO, they can take PTO. If they have sick days, they can take sick days. You may get into FMLA, depending if the employer has enough employees to actually trigger that, but you'll need doctor's notes and everything like that. And of course, we get into that area of, is this actually a health disclosure that could be violating HIPAA? If you have a big enough office, you can go and say, hey, we had someone test positive for COVID. Go ahead and take precautions if you were by this person or whatnot. When you are in smaller offices, you may not go and say someone tested positive. You can't go and say Jill tested positive, but you could still say someone tested positive. And then when Jill's not there because she's quarantining for 5 days and then may come back with a mask, it might be pretty obvious that Jill tested positive for COVID. You need to just work through that. Again, don't go and disclose it. You can ask the employee for if they consent to you sharing their name. If not, keep it general and say, hey, we had someone test positive. But get the employee's permission on that to go and say by name before you do that. But everybody has to be safe. And again, we're 2.5 years into this where I think we're getting to a level of normalcy with this, of people testing positive and missing work and going from there. The other things that you can do mandatory testing. That is consistent with the EEOC and federal law and state law on that. You can go and say, you need to have a negative test before you come back. That is a possibility. But now I believe the CDC is recommending that moving forward, you have you mask for 5 days when you come back. So that's really up to you as an employer, if you want to say you need to show me a negative COVID test before you come back. But then again, depending on the severity of it, they may have been working from home remotely anyways. And again, got to have a little bit of a sliding scale here. I don't love sliding scales all of the time, but this one is you have to be able to react to each individual situation of what's going on. And so, like I just said, wear a mask, quarantine for 5 days is right now the protocol for the CDC. And then, 5 days wear a mask until day 10. Now, there is some still question on what does that mean? Is it 5 days from the positive test, or is it 5 days from the first symptom? Well, sometimes symptoms aren't there. So how do you really run the test? And again, the way that these tests are working is you're not testing positive until really after you're feeling crummy, or after that part where you may have been already exposing. But that you can do that and follow the CDC. That changes every now and then. So you may want to refresh yourself if it's been a while since your last COVID positive, and you go and look at that online to find out what to do. If you're exposed and you don't have symptoms, you can wear a mask. Then at day 5, get tested. COVID symptoms have changed. Each mutation is different of when it's positive. And I know there's a lot of discussion on masks. I'm not going to get into that. What's an appropriate mask, what's not an appropriate mask, what's an appropriate face covering, and all of that. If you want to get into that, what type of mask you should have, I'm sure there's some guidance on the internet about that. And again, there would be nothing prohibiting the type of policy if you required a specific type of mask. The only thing I'd say about a specific type of mask, be open to maybe needing to change a mask policy, because I know some people, for health reasons, have issues with some of the more medical type of masks. Again, be willing to be flexible on that type of issue, and all that. So, well, next topic, kind of hit on COVID. Again, nothing really has more developed on that about mandates and vaccinations, but who knows what's going to happen again this fall or in January or anything like that as things develop. As that leads into, I mentioned it several times, are remote workers. We've entered into an age where this is more and more common. It was probably before COVID, there was still people working remotely, and when COVID hit, they didn't think much of it. Now everybody's probably had to work. A lot of people have had to work from home. Some people love it. Some people don't love it. Some people are now working in Nebraska for companies remotely in California or New York or wherever. And that gets into a whole different type of challenge of what happens. So generally speaking, the big question is, if I'm in Nebraska and I work for a company in California, whose laws are going to apply? And, there's not a real specific rule on that, but there are ways to kind of look at that. If you have an employment contract, those always have this type of law applies. Then there's some other factors of what goes on this. And I will tell you that Nebraska likes to have a policy that says, for public policy reasons, our laws should apply to our employees working in our states. And so if you're working at home, even for a California company, Nebraska is going to think our state laws should apply. And so that's what employers need to be cognizant of. Hey, I have an employee here that our business is located in Nebraska, but the employee lives in South Dakota or Texas or Oregon or some other state, what do I do when that person's working remote and is doing work for our Nebraska company? Well, you might have a couple of laws apply. And you have to be cognizant of what those laws in those other states may be. So you may need to talk to an attorney in those other states to say, hey, I'm doing this. It's fine in Nebraska, but is that fine in Texas? I don't know. Each state has their own laws. They get a lot of them have the similar laws, and federal law, depending on the number of employees that have those triggers of when those hit, federal law is going to be the same. But each state has their own employment laws, and you have to be cognizant of that as of an employer. Right, like I said, right here is presumption Nebraska has the public policy. Then you run into income and business taxes, workers' compensation. That's a big thing. If an employer is working remote and even if they're at their home and they're injured in their home while they are on work, they could be compensated for worker compensation benefits. The same analysis will go is, were they injured in the course and scope of their employment? And if they're working remote, and even though they go and trip on their area rug and break an arm or something like that, that could be compensable under workers' compensation laws. I've seen a couple of them, and and I get it from the employer's standpoint. It's like, well, we didn't even create this hazard. That's their own hazard in their own home. And how do I know if they were really working? Well, if they clock in and out, you're going to have to look at their timesheets and see what they were doing before and after. And then you get into, just like you would with any other workers' compensation lawsuit, or even claim, not a lawsuit necessarily, but a claim on that, notice and everything like that. So even if you have remote workers, employers carry work comp insurance. That's still going to be a requirement by Nebraska law, and I would suspect in any other state jurisdiction, because they all have workers' compensation courts. Got to have comp insurance if you have employees. So get comp insurance even if you have remote workers. And then you're going to have to talk to your comp insurance company to say, okay, well, I have a remote worker in California or Texas or Nevada or wherever. Make sure that they're going to have that conversation with your insurance company to make sure that's going to be covering them, because then you're going to be subject to most likely the compensation court in California if the remote worker was injured there. That's going to be how that works. So you have to be cognizant of that. Not saying you need to go become an expert in all your California compensation law, but if you have workers there, you need to be cognizant of it. You don't have to become an expert in it, but you need to be cognizant of it and make sure that your insurance company would cover remote workers. One other thing that I've seen happen with remote workers is that they don't like to stay in one place. I know it's kind of a trend with maybe some of the younger workers that they may be from Nebraska, have an apartment in Nebraska, but then say, well, I'm working remote and I'm getting paid, so it doesn't matter where I work. I might go to work for a month in New York. And you as an employer may not know what they're actually doing. Got to be cognizant of that, because then what jurisdictions apply in there where you thought you hired a Nebraska attorney, or excuse me, a Nebraska employee, where they were saying, hey, they lived in Nebraska and they're working remote. They went and then spent a whole week in New York doing work. You gotta think about the implications of that. Does now New York law apply? And you have to, that person has to pay income tax in New York and everything. Maybe. I don't think all that is fully developed, but the law typically is you're subject to the state's tax laws where you worked at. So even if you worked in Nebraska, and this is not remote, but if you worked in Nebraska or lived in Nebraska and go to Iowa to do your job, you're subject to Iowa's tax laws when you're doing that. So employers and employees need to be cognizant of that. And there's nothing to stop an employer from saying, you need to let us know if you're doing that as a remote worker. Open up that conversation. You're not preventing them, but you as an employee, as an employer, need to know how that's going to come and affect you for other laws and everything like that. So be cognizant of it. Have conversations with your insurance companies. Have conversations with your accountants. Have conversations with your attorneys about, do I need to update my employee handbook? Do I need to do something else to bring me into the realm of being compliant? Remote workers, again, this is something that's really popped up in the last 2.5 years of how to navigate all of this. And with that becomes the other challenge of, can I start forcing them to come back in? And that's a shift of, that's going to be a company decision. You don't have to allow remote working again, unless you want to do it as an accommodation. But I don't know how that's going to affect employee morale. Some people love it. Some people love remote work and doing all the work from home. Some people miss the office of going and chit-chatting and having the idea of, okay, there are people here, I can talk to them, I can see them. I'm not in my house 24/7. That's really going to be up to the employer, but you want to take the temperature of your employees before you start mandating everybody coming to the office. Because it's hard enough right now with people finding employees to work. Every industry across the board I know is struggling with that. So be cognizant, and maybe some flexibility on that would also help. Wage and hours, this is nothing new. This has always been there. Go over current minimum wage for Nebraska is $9 an hour. Federal is $7.25. And I know there's been discussions that these numbers need to go up across the board. There is an initiative in Nebraska to raise the minimum wage. And on this slide, you can see kind of what that would be to eventually get it up to be $15 an hour. Wouldn't it happen automatically of going from 9 to 15? It is a gradual increase. So it would help employers with that. But that's kind of where we're at. And I know that is a huge discussion across the board about wages. And it's been really competitive out there with wanting to pay a living wage, and now employees not wanting to work. And you're looking at it of, I could go work for this, what used to be a minimum wage job at a big box store or something like that. They're now paying $15 to $18 an hour. And that's leaving other employers going, I can't compete with that. Or that's just, they're outpricing that. I can't get those employees anymore. Now, your job quality may be better, your living may be better, but at some point you're going to have to look at that. And this is, again, across the board. It's not one employer, but it is across the board of competitive wise. How do you compete? And raising the minimum wage, yeah, it's going to affect, but if people can go out and get jobs that are already well above minimum wage, this may not just solve that issue. But be mindful of it. I don't know the temperature if this is going to pass or not. I wouldn't be surprised if it passes, just because that's the nature where it's at. We've been stuck at $9 for several years now for minimum wage. Plan ahead if your industry hasn't already looked at it and said, well, we need to start paying more regardless. So that's what's going on locally with wage and hours. Next is overtime pay, and that is controlled by the Fair Labor Standards Act, where when is overtime owed, and when are they exempt from overtime? These are the categories I've listed on there. Each of these have their own definition and analysis of how this works. And you have to be cognizant of it. It's sometimes not a one size fit all test. If you have questions and you're on the fence, you may want to talk to an attorney of if that person is going to qualify as an exempt employee. So job duties, what they're supposed to do, are they making decisions? Can they make decisions that bind the employer? Those types of things you may not necessarily have to pay overtime to. The other requirement of that is about wage. So it's called the salary and duty test. Determine whether the employee falls under the exemption. The first one, we've talked about duties. Those are what we just talked about over there. But the other one is salary. And if you look at the bottom of the slide, it's $35,568 per year. There are, coming up soon, there's going to be a discussion of should that be raised, because $35,568 a year isn't a ton. I mean, it's not a ton of money compared to some of those other positions that you think of, like as an executive or administrative or professional. If they're not making that much, you have to be concerned that they maybe need to be made more. And then that gets you to the whole overtime. So the 35,000 is a floor. If it's below it, they don't qualify and they're owed overtime. It's above and they meet those duties, then they're going to qualify, and you as an employer don't owe overtime. But something to be cognizant of, this goes with the minimum wage that I talked about before. When that number keeps changing, you need to just be cognizant of that. And you might be above that anyways, regarding that minimum number. So that should be coming, that proposal is going to be coming later in October. Overtime is going to be addressed on that. What that number is right now, I don't know off the top of my head. And they may be looking into making that become automatic. So probably to adjust with CPI or something like that, that every 5 years or so, or even every year, it goes up by X% to track with the growing needs on that. And so we don't have to go through a formal process. I wouldn't be surprised if that is the way that if it does, the automatic one makes a little bit more sense, so it can track with it automatically, so that our laws don't get so far behind, and to add a balance with what kind of today's society is going on. But I don't know if that will do it. But we're in the initial stages, or coming up on that soon. So we'll go from there. Finally, just wanted to give some essential topics and policies that need to be in your employee handbooks. Again, a lot of things with these policies a lot of it's going to be triggered depending on how many employees you have. So federal law, Title VII, everything like that, you need 15 employees before it can trigger. In Nebraska, the Nebraska Fair Labor and FEPA, Nebraska Fair Employment Practices Act, that also triggers at 15. But in Nebraska, you have two cities, Lincoln and Omaha, that have city ordinances that go and control, have ordinances on discrimination and everything like that, where it is 3 employees. And so you have to be cognizant of that. And those policies have, some ramifications of what's going to happen. So go through these here that say, or general rules and regulations of the company. How are you going to administer discipline? Not saying you shouldn't have your own discipline policy, but general rules and regulations of the company. I don't know what those are or what each company has. I generally have some standard language in there, but you need to have that. When you're talking about discipline, a progressive disciplinary policy is fine. I have nothing against that, but you always want to reserve the right to terminate immediately. Nebraska is an at-will state. And that means that the employer or the employee can terminate the employment relationship. And while you want to say there's a third warning and a second warning, and this happens on each one, sometimes the acts are egregious enough that you want to terminate immediately. So you can do that, but reserve that and make sure that's in your employee handbook, so they know you can terminate immediately. That's always difficult for some people to understand as employees that no, they just terminate. Well, it's an at-will state. It goes both ways, so that helps the employee that way too. You want an equal employment opportunity policy in there that says that you don't discriminate on race, color, age, those types of things, because that should be true and you should be following that. But with all of these policies, the whole reason that you want these policies are because if you get to the point in your and you get an NEOC complaint or an EEOC complaint, they're going to come and ask you about your policies. They're going to say, show me your anti-harassment policy, show me your equal opportunity policy. And if you don't have it, that's not going to look good. Because that's not going to help you down the road in that litigation. Or if the EEOC comes and says, nope, where you reached an agreement, these are the policies you need to have. So you need to have those in line, and you go from there. I get it. It's sometimes hard when you don't have 15 employees and you say, why do I care? I don't have this many employees. Still a good idea. Still a good idea because it kind of shows how the company is handling things. Be it if you have 4 employees or if you have 40 employees, it shows what policies you have. Anti-harassment, these are the obvious ones. Can't discriminate or have people harass other co-workers based on race, color, religion, gender, national origin, age, disability, marital status, service in a uniform services. And sex is in there too. Can't have sexual harassment. Nobody wants that. Cannot have it. Now I mentioned marital status. That's a requirement in Nebraska. That is not a requirement federally or even in every state, but marital status, you cannot be discriminated against based off of your marital status. So if you're married or not married, they can't look at you and say, oh, you're married, I don't want to hire you because you're not going to work as much. Can't do that. That is protected. So while I say these are obvious, they happen all the time. And it is unfortunate that it happens, but you need policies on there. And as an employer, you may need to train employees on this, and then train upper management or the hiring individuals, HR or whatever, on this of what they can and cannot do. Regarding age, that's 40 plus. Anybody over 40 is considered in that older worker, even at 40, and you can't discriminate against them. You can't fire. It's going to look bad if you fire that person over 40 and you go and replace them with a 23-year-old. A lot, it usually happens from when I've seen it is when they are older, closer to retirement age, and they get fired, and then they're replaced by a younger employee, but can't always do that. Now, if you don't replace their position, or somebody else just absorbs their job duties, that's not necessarily a bad thing. That can be done. FMLA, you need 50 employees. If you don't have 50 employees, you don't need an FMLA policy. Now, that's 50 employees in a 75-mile radius of the work site. So there are some situations where a larger company has over 50 employees, but they have 30 at once. They have 30 at one site, and then outside of that 75-mile radius, they go and have another 30. So then they would not be subjected to FMLA. So be cognizant of that. You don't need an FMLA policy. There are, in Nebraska, there's no requirements for how long PTO or anything like that is, or vacation use. I typically recommend to separate sick days from PTO. Sick days, the employee doesn't get to take those when he or she leaves the company. PTO, they do. So you can separate that all out and say, look, you have so many sick days and you have this many hours of PTO. And if they take PTO and you are an FMLA employer, you can run their PTO concurrently with their time off at the while they're taking their FMLA. Next is an injury prevention program. Need to have this. This just kind of goes through and see what your business is, of what are potential workplace hazards, and training regarding the hazards associated. If you have chemicals and stuff in the office, you need to have those MDS sheets that go and say what the hazards of that chemical or cleaner is. So even if you have a supply closet and you have general cleaning supplies and everything on that, yeah, you probably need to have your MDS sheets on those as well, because it is technically a hazard and you need to have those. Same with safety and health hazard reporting. If there's hazards in your workplace, you need to be able to allow your employees to come and report it. Now, again, general office settings, is that common? No, but you still probably should have a policy to say, hey, if you notice something hazardous in the office, please come and report it. Drug-free workplace, again, that's pretty self-explanatory. This is required if you are an employer that has a government or state contract worth over and you do over 100,000. They're going to require that you have a drug-free workplace. It's a good idea to have anyways, and I don't know why you wouldn't want to have that, but you should have that in there. Nursing mothers, this is to allow them to go and breastfeed or pump, whatever they need to do. And it is only available to not exempt employees, and they only get it for 1 year after the child's birth. So cognizant of that, what this means is they need a place that is not the bathroom, but a place where they can go in the office and not be bothered, so that they can pump. And that can be a little difficult sometimes, but if you have one, you have to give them an area. If the person has their own office, great, they can close the door, let them do that. But if it is a secretary or something like that that doesn't have their own office, you got to set up a spot for the person to do that. And just be cognizant of that. It is for 1 year that they get to do that. Complaint procedures, allow your employees to complain. Whatever it is that they have going on, let them know what the complaint procedure is. And that could be going to their general supervisor, but if it's the supervisor that they need to complain about, they need to be able to go to the HR. If it's HR that they're complaining about, they need to be able to go to the owner. If it's the owner they're going to complain about, they need to be able to go to HR. They need to have an outlet of someone other that is doing the actions that they're not liking. They need to have an outlet to go make that complaint. Now, it doesn't mean something has to happen because of the complaint, but they need to be able to make the complaint. And workplace violence, need to have a policy on that too. Do an assessment to see, what type of violent, how susceptible is your business to workplace violence? It can happen. OSHA has some guidelines on that for the different industries that are in there, and then just kind of have a workplace violence prevention policy of how it's investigated, what's being done, just kind of how to go from there. So with that, I will end the presentation and open it up for questions.
Thanks so much, Chuck. That was a really insightful webinar. I think that we could probably do one of these every day on employee handbooks and still have enough information. So, it's a lot that we need to all be aware of, but there's a few questions here from attendees. I'm not quite sure if you already answered the first one, you can let me know. But somebody's asking, can you ask for any kind of validation for the religious exemption, a note from their religious leader, etc.?
No, you don't get to do that. You can ask that individual questions for them to explain it. But again, it doesn't need to be from a religious leader or from their pastor or priest. Again, because these aren't just tied to a specific denomination of religious or Christian